5 seconds to go. Start. The cause of action arose when the idols were placed in the inner courtyard. This arose even before the proceedings under section 145, and hence the fact that the magistrate has not passed any final order would not lead to limitation ceasing to run. Both the Limitation Act 1908 and its successor, the Limitation Act of 1963, are statutes of repose. Extensions or exceptions to limitation are stipulated in the statute. These provisions include sections 4 to 11, sections 12 to 25 dealing with computation of the period of limitation, section 26 acquisition of the right of easement in 20 years, and section 27 modification of 20 years for a reversioner of servient tenement. Article 47 of the Limitation Act 1908 applies to a suit by a person bound by an order respecting the possession of immovable property made under the Code of Criminal Procedure 1898 or the Mamlatdars Court Act 1906, or by anyone claiming under such person to recover the property in the order. The period of limitation is 3 years and time begins to run from the date of the final order in the case. In order for Article 47 to apply, the suit must meet the description specified in the first column. In other words, Article 47 applies only in a situation where a magistrate has passed an order respecting the possession of immovable property. When no order regarding possession of immovable property, which is the subject matter of a proceeding under section 145, has been passed, the suit shall not be of the description specified in the first column. It is only if the magistrate has passed such an order that the suit would meet the description specified, and in which event Article 47 would govern. However, though Article 47 is not attracted, a person aggrieved by the order of attachment may file a suit for declaration of his right. On the determination of the right by the civil court, he would become entitled for possession, and the magistrate is duty bound to hand over possession in accordance with the order of the civil court. In the present case, absent any order respecting possession under section 145, Article 47 on its plain terms has no application. The next limb of the submission on the basis of which the bar of limitation has been urged is that suit 4 is governed by Article 120. Now Article 120 deals with suits for which no period of limitation is provided elsewhere in the schedule. Article 120 is in the nature of a rescissory provision. Hence, where a specific article in the schedule applies, the rescissory article can possibly have no application, and it is only when the suit does not fall within the description specified in any other article that the rescissory provision would govern. The two competing articles which have been pressed in aid on behalf of the plaintiffs are Article 142 and, in the alternate, Article 144. Article 142 covers a suit for possession of immovable property when the plaintiff has either been dispossessed while in possession of the property or has discontinued the possession. Dispossession postulates an act of an involuntary nature, while discontinuance is more in the nature of a voluntary cessation of possession. In the present case, the plaintiffs in suit 4 have sought a declaration that the property indicated by the letters A, B, C, D is a public mosque and that the land delineated by the letters EFGH is a Muslim graveyard. Besides this, the plaintiffs seek a prayer for the delivery of possession in case the court is of the opinion that such relief is deemed to be the proper remedy. Stop.